Strawn, take one.
Mark, it's great to be with you here on stage at the Goodman Theater, right across the street from Winston and Strawn's Chicago office. And we are here to talk about trial lawyers and storytelling in honor of the opening production of the Goodman's 2024-25 season, which is Inherit the Wind, a play about trial lawyers. You've been a trial lawyer with the government for a long time, and now you're a trial lawyer in private practice. Do you have models in fiction that inform your style as a trial lawyer?
I don't know if I can pull off his style, but I will say that Jack McCoy from Law & Order, even though he was a prosecutor for a long time, he never became cynical. You could always see in the way he conducted himself in the courtroom that he cared about what happened in his cases. And so I always admired that character in that show. I don't think I was ever the prosecutor that Jack McCoy was, but I tried to be.
So telling a story in a courtroom starts with opening and ends with closing, but there's lots of other ways that the story gets told. So how do you think about weaving the story through the entire presentation, including the presentation of evidence, as opposed to just focusing on the opening and the closing?
Yeah, I always start with what is the core, the very center of my case, the theme. For example, every fraud case that I've ever been involved in, some of them have been incredibly intricate in terms of how they're carried out. But every fraud case that I've ever met has the same core, which is one person lied to another person in order to get their money. And that is something that everybody can understand. You've got to get to the bottom line and explain that to the jury and think about what is the lie? What is the lie that was told here? And where did the money go? And if you focus on that bottom line throughout the case, and you start with it in your opening and you end with it in your closing, then that's what the jury is going to be focused on too.
Can you think of a case that you've handled, either as U.S. attorney or in private practice, where the storytelling really made a difference?
You know, one case that comes to mind, and this is because the story is something that was really foreign, I think, to the jurors, not familiar territory, was a sex trafficking case that I tried as a prosecutor. And that was a case where a man was charged with trafficking multiple teenage girls, and he was charged with trafficking them through force and fraud and coercion. And the challenge was that these victims all had an opportunity to leave at one time or another, and some of them did leave, and then they came back. And so the challenge was trying to explain to the jury how that could still be force. And we really focused on explaining to the jury how things look through the eyes of a teenage girl in that circumstance. And so to take one example, we told them the story of this girl who was, when she met the defendant, she was living in a homeless shelter that she had to sneak in the window to get in at night because she wasn't allowed to be there. She had no place to live. She had no source of money. When he met her under those trying circumstances and took her back to his house and gave her something to eat, and over time told her he loved her, and built an incredible bond with her, and then eventually impregnated her and sent her out on the street to commit sex work while she was pregnant and while she was visibly pregnant. When you sort of give the jury that picture, it's not hard for them to conclude that this is not something that someone chooses to do voluntarily. And all of those details really matter, and they really cause the jury to not look at the world through their frame, but to look at it through someone else's frame. And that's when I think they understand the evidence that we're presenting.
So the audience in a courtroom is the finder of fact, whether it's a juror, a jury, or a court, the judge himself or herself. How do you modulate what you're doing as the storyteller to the reactions of the audience?
You're always trying to read your audience. And as a trial lawyer, one way you can drive yourself crazy is trying to figure out what are they thinking. Maybe it's because I started as a prosecutor where you have to win a unanimous verdict, but my approach has always been, if what I'm saying can't convince 12 people who got picked for this jury, then I'm probably doing it wrong. And so I really try to craft a message that will appeal to the 12 people that I'm supposed to persuade.
What do you find most rewarding about being a trial lawyer?
I think it is in some ways the ultimate test. I mean, if you think about it, we've got a dispute and we're going to resolve it in public, and each side gets to present their case. And we've got this group of people who's been chosen because they've pledged to be fair and impartial. And you get to argue to them, and you get to present evidence to them, and then they decide. And in some ways, it's the ultimate meritocracy. Can you convince them or not? And I love the competitiveness of that, and I love the challenge of it.
So you were a trial lawyer for the government, the U.S. Attorney in Iowa. You came to Winston. Then you went back into government service for a period of time in Washington for the special prosecutor. And you came back. What made you come back?
Well, what I'm getting from your question is that I can't hold down a job. But the truth is, I was always planning to come back to Winston. I have absolutely loved my experience here. And I think in part it's because it's a firm that greatly values trial lawyers and seeks them out and supports them and tries to develop the next generation by training associates to become trial lawyers, and supports that practice and supports its people. So really the reason I came back is that I like my work and I like the people that I work with, and as a lawyer that's really everything. So that was an easy decision.
Winston has a reputation of being a trial lawyer's firm. Do you think that's true? And if so, why?
It's absolutely true. And I think, if you look at just people with backgrounds similar to me from the U.S. Attorney's Office, Governor Jim Thompson, Dan Webb, some of the legendary lawyers in recent Chicago history are Winston and Strawn attorneys. And I think it's because the firm prioritizes that. It recruits people with that in mind, and it also develops people to become trial lawyers. I can't tell you how many associates I talked to who just got finished with a speaking role in a courtroom because Winston really pushes its lawyers to develop those skills from the beginning. Trials are really intense. They're stressful. You're not getting a lot of sleep. By nature, you're fighting with the other side in public. And so it can be hard to always be courteous and kind in that context. But I found the ones that juries like are ones that are courteous and kind all the time, because jurors appreciate it when lawyers treat each other and witnesses well, and they're uncomfortable when people are squabbling. Human beings are naturally uncomfortable watching other people squabble. And so the challenge is to combine that competitive fire with a genuine kindness. And those people who can do that, I think, are the most effective trial lawyers.